I'm Dr. Jill Vecchio. I'm a practicing radiologist who's read the healthcare law, and I'm here to talk to you about it. We're here to cover the next segment called Judicial and Constitutional Issues. We've already covered coverage, who will be covered and how, costs, state healthcare exchanges and how employers will be affected, how this law affects doctors and you as patients. This is our next segment. Judicial and constitutional issues. I think you'll find this really fascinating. Right now there are 28 states in the process of filing lawsuits. 30 states have either filed lawsuits or filed waivers. So actually 4 states have been granted waivers from the employer requirements, and sometimes the entire states, like the state of Nevada, has been issued a waiver so that they don't have to comply with the insurance requirements of the PPACA law. Vermont was issued a waiver because they want to start their own single payer system. So there are different reasons for people wanting to file for waivers. Some of the reasons that these lawsuits have been filed are based on the individual mandate under the Commerce Clause, and we'll talk about that. Massive increases in state obligations for funding and oversight of programs, primarily the increased costs, as we covered in Section 2, the increased cost to the states of providing for the increased number of enrollees in their Medicaid programs, and the child health programs. That's going to increase, in some cases, billions of dollars to the states in their obligations. The 10th Amendment, we'll talk about the 10th Amendment and how that interacts with the Commerce Clause. Some lawsuits also involve union exemptions on the Cadillac plans. So the Cadillac tax of a 40% tax on health care premiums that exceed a certain number that's mentioned earlier in the law. We didn't talk about that very much, but the unions were made exempt in the law from that. And there's a question as to whether or not that's actually constitutional. Surprisingly, Roe v. Wade, the law that is so controversial about abortion, actually has a segment in it about doctor-patient privacy that may come into play somewhere in these lawsuits. Remember, the way that this healthcare law, and I'm not going through all that because that takes several minutes to go through how this law was passed. But the way that it was passed was not typical for a revenue-producing bill. In their rush to get this passed through the Senate and then the House, and then back and forth between the Senate and the House to get this and the reconciliation bill all passed, they neglected to put in a severability clause. So when we all sign a contract, usually at the end of the contract it'll say, if any part of this contract is found to be unlawful or blah, 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 then that part is severable, or it can be removed from the contract and the remainder of the contract will still be in force. So this piece of legislation, PPACA, does not have a severability clause. So that theoretically, if the individual mandate were found to be unconstitutional, it may be that the entire law would be found to be unconstitutional. The severability clause and whether or not it can be used that way is also debatable. So everything's up for grabs at this point. So some people say that the legislation should have a severability clause, and other courts have said no, it doesn't have to have a severability clause. That's why it gets really confusing. Let's talk about the 10th Amendment. So in the 10th Amendment to the Constitution, it says that in this Constitution, throughout the Constitution, it enumerates or gives power to the federal government to do certain things. Healthcare isn't one of them. Healthcare is not among the enumerated powers of the federal government. So the 10th Amendment says that anything that isn't one of the enumerated powers of the federal government is reserved for the states to decide on. Okay, so keep that in mind. Healthcare is not one of the enumerated powers. So the Commerce Clause kind of counteracts that a little bit. The Commerce Clause refers to Article 1, Section 8, Clause 3 of the U.S. Constitution, which gives Congress the power to regulate commerce with foreign nations and among the states, and with the Indian tribes. Congress has often used the Commerce Clause to justify exercising legislative power over the activities of states and their citizens, and in bizarre ways. There are so many interesting cases where the Commerce Clause has come into play, and how it's been interpreted, and the facts of the case are amazing that they put this under the Commerce Clause. So the Commerce Clause and the use of the Commerce Clause has evolved or devolved, however you want to look at it, over the years to be widely encompassing. The problem is the Constitution does not explicitly define the word commerce. So it's left for the courts and in different phases of society and so forth. The term commerce has come to mean a very broad entity. So, considering the individual mandate, a federal judge in Virginia upheld the law, saying that the legal challenge to health care reform law, I hold that there is a rational basis for Congress to conclude that individuals' decisions about how and when to pay for health care activities substantially affects the interstate health care market. So the idea is that the individual mandate is constitutional, in their view, because when patients choose not to get health insurance and they incur medical costs, those costs are then passed on to taxpayers and citizens in that state. Now, how that falls over into other states I find interesting. But the idea is that by forcing other people to pay for their health care coverage, which may or may not actually happen, that's affecting that falls under the Commerce Clause. That's the argument for the individual mandate. Now, in Virginia filed a lawsuit, and it actually kind of has three parts. It's more complicated than that, but I think about it as three separate parts. So, in the first place, the Virginia voters passed a bill prior to the passage of PPACA that made it illegal for the federal government to require individuals within the state of Virginia to purchase health insurance. Okay, keep that in mind. That's part one. And other states have done similar things. Virginia, the second part, is against the individual mandate. So, according to the Attorney General for Virginia, he says that the mandate that requires nearly every American to be insured by 2014 violates the Commerce Clause. The third part of the Virginia lawsuit was that the health care overhaul is expected to cost the state of Virginia $1.1 billion over 7 years, beginning in 2015, mainly as a result of the new Medicaid requirements. So remember that the federal government will help pay for new Medicaid enrollees, but only for 2 years. After that, the states are on their own. So Virginia has estimated that $1.1 billion is what it will cost them to cover these new people. They don't have the money. Few states do. I don't know if any state does right now. Now, Florida also filed a really large lawsuit. That's the biggest one. So 28 states are involved in the Florida lawsuit, as well as the National Federation of Independent Businesses, and there's some other plaintiffs involved in this one as well. Similar arguments, though, primarily the individual mandate, but I think they also argue against the increased burden on the states to cover Medicare. So let's talk about how the federal court system works a little bit. There are circuit courts that cover between maybe 2 or 4, I think one of them maybe even covers 7 different states. So the circuit court, the federal circuit court, like for the Florida or Virginia case, may not even be located in that state that's filing the lawsuit, but they'll rule on that lawsuit. So 4 circuit courts have ruled. 1 shot down the individual mandate and said it was unconstitutional. 3 other ones said it was. It could be upheld. So it's been a really interesting little battle to follow. Republican appointees versus Democrat appointees, and they've come up with some surprising rulings. So now it's up to the Supreme Court. Now the Supreme Court can decide several things. They can decide that they're going to hear the individual mandate argument only. They can decide they're going to hear the individual mandate based only on the Florida case. Or they may say they're going to put the Florida and Virginia cases together and hear the individual mandate. Or they may add in, well, we're also going to add in the part about the increased burden on the states for Medicare enrollee coverage. Or we're not going to hear that. Or we may take something from a totally seemingly unrelated case and we're going to add all this in and we're going to rule on all these things. So it's really interesting. The Supreme Court gets to make all these decisions about how they're going to approach this subject. Now, and So they're going to rule on maybe a combination individual mandate, burden on the states, and whether to allow states to vote to exempt themselves from the health care law, because that's going to be an issue. Several states have passed legislation to that effect. What if the individual mandate is upheld? The federal government will have the power to force Americans to purchase any goods or services they deem necessary, justified under the Commerce Clause. I'd like for you to think about that for a second. If the federal government can force us to purchase health insurance just because we exist, there is no limit to what they can force us to purchase at any other time. Now, that's our best bet for having the Supreme Court shoot this down. They understand the importance of the Commerce Clause and limiting it to some extent. Now, they may also find some way to limit their ruling that will still uphold the individual mandate, but will limit the use of the Commerce Clause in the future. We'll have to see. If the individual mandate is not upheld, then they have to make a decision. Is it severable from the law, or is it not severable? If it is severable from the law, then that makes it worse. Then the whole law costs that much more, because now we don't have the money coming in from penalties for people not getting insurance to offset the costs of all this stuff. Wow, that's going to make it so much more expensive. So in a way, it makes it worse. But if they shoot down the individual mandate and say that it is not severable, in other words, if that individual mandate can't be separated from the whole law, then the whole law falls down and it's gone. So this is going to be very interesting. What's also interesting is that the Supreme Court is going to rule on this in about June 2012. That's about the same time that the Republican and Democratic national conventions are happening. This is going to be one banner year for us as Americans. But think about what the costs might be to us from this law. It may be that the greatest cost to Americans from the Patient Protection and Affordable Care Act is our loss of freedom. So now you've got a good idea of what some of the judicial and constitutional issues are and what some of the biggest costs to us as Americans will be. One of the things I want to point out is, even if the Supreme Court upholds the mandate, strikes down the law, so many things are already in place in anticipation of this law going into full effect that we really need to repeal the whole law, in my opinion, in order to get rid of all of the effects. Our next segment is going to be ideas for real healthcare reform. I think you're going to like this. So stay tuned. Thanks.